Paralegal Live, powered by OLH Group, is an open forum where audience-submitted questions are answered in a general manner. This broadcast does not provide formal legal advice. If you require formal legal assistance, please book a consultation with our office. Thank you.
All right, we are live. Beautiful. Caleb, I love doing these live sessions with you.
Yeah, it's really awesome.
Thanks for joining with me again. My name's Paul J. Roulard, founder of Ontario Landlord Help Group. Today is Paralegal Live.
Yeah.
On Wednesdays, myself with Caleb Minta, our licensed OLH Group paralegal.
Yeah.
Good to have you again.
It's good to be back.
Oh, this is so great.
I love being on here.
You know, we have some great questions again.
Yeah.
We just kind of scanned through these questions quickly. We almost have a full hour dedicated here with these paralegal questions. Just a very quick reminder for landlords: you can register your questions, and that goes into our system, and that gives us the ability to screen the questions first. Make sure that they're good questions for landlords and ones that are going to be useful to help landlords. And you want to get them registered because we get a lot of questions and we can't answer every single one of them.
No, it's if we had the time, we would, right?
Yeah, absolutely. So we can't answer everything. So get those questions registered, and basically it's first in line.
Yeah.
Right. But let's dive right into it. This week is going to be really unique, actually, because we're growing with what we're doing here, and we added a little bit of a bigger operation here, which I think our audience is going to see it compared to last week.
Yeah, it's definitely expanded.
Yeah. So hopefully we don't have any technical errors. We probably will. If we don't, just know that the cameraman just behind the camera here, he's going to get in trouble.
Yeah. He's already sweating.
All right, I'm just joking. Let's roll right into it. Let's have fun with this. Thanks, landlords, for joining in. And if you are on YouTube, check the description. We have links to everything that we're doing. It's going to be some really useful information for landlords all across Ontario. So let's dive right in.
Yeah.
For our first question, sorry, I'm going to scroll up here. Okay, so does the tribunal encourage negotiating an offer for a T5 and an L10? Does this offer get posted to the portal, and a DRO would be assigned to make the offer binding?
So a DRO, I'm assuming they're talking about dispute resolution officer. So if you've ever been to an LTB hearing, oftentimes what will happen is an adjudicator will ask you if you'd like to go to mediation before you actually have your hearing, and those mediations are conducted by dispute resolution officers. They're not making binding decisions or making binding orders. Their job is to assist the parties to come to a resolution, organize and organize a discussion so that you get to a place where you're both going to be happy, right? In this regard, the only way to make an offer or a resolution or a settlement binding is to get an order from an adjudicator. Mm-hmm. These are called settlement orders. Without an adjudicator making that order, it's not binding. But the LTP, yes, 100% does encourage negotiating and resolving without going to a hearing. They like to see landlords and tenants resolve their matters without arguing in a hearing.
Does that happen often, or who would initiate the negotiation process?
So either party can. So it could be the tenant reaching out to the landlord or landlord reaching out to the tenant. It can be done through the portal, right? But most of the time, at least when I'm practicing, it's an email or a phone call to the tenant, or the tenant is reaching out to us, right?
Okay. So if we just wanted to, I guess, can maybe give us an example. Let's just say that we're willing to, pay the tenant to leave, a cash for keys or something like that.
Yeah, so like it's a cash for keys agreement. So I might call the tenant and say, look, your landlord is satisfied with just giving you X amount of dollars, right? Mm-hmm. And if you sign an N11, terminate the tenancy, they'll agree to give you this amount, and then you can move out on that date, and that will resolve
and that
it.
can be done through email.
That can be done through email, phone call,
Yeah.
even in person. Yeah.
This particular question mentioned on a T5, an L10. Could you give some type of scenario on that?
So I'll talk about an L10, for
Sure,
example.
okay.
So an L10 is usually filed after a tenant has vacated the unit, right? This is usually for monies, right? So it's either for like damages,
Right.
costs, or like rental arrears that the tenant left, before they vacated the unit, right? So you might submit that application seeking those rental arrears that the tenant still owes you, and maybe you might say to the tenant, look, they might owe you 15,000. You might say, look, why don't you just pay me 10,000? We'll call it square, and you go about your business, and I'll go about mine.
Right, okay.
It might be that type of thing, right? Or it could be, you can be as creative as you like. You can waive rental arrears for some kind of exchange or something. There's no limit to what you can agree to between the parties, right? So, it's always best to be open and not closed-minded when it comes to resolution, because there's a lot of ways to resolve matters that a lot of times landlords don't think about. So, yeah.
I love talking to you, Caleb. You're just so thorough with your answers. That was a great question. That's a great answer as well. Anything you want to add on to that one, or?
Yeah, I would just say if you do have an application, and even if you're a tenant or a landlord, it doesn't matter if there's an application that you're kind of before the board for, and there's an opportunity to mediate. There's nothing to lose by having a discussion. A lot of times parties don't want to even talk, like, oh, I'm not going to talk to you. But you don't have anything to lose by just talking and seeing. You might be surprised how willing either party might be to squashing the issue. Yeah.
I mean, we find that in many cases anyways, where we're negotiating or coming to a conclusion before we even get to a hearing.
Yeah.
Most cases, that's what we want to do.
Yeah.
We want to find, a common ground.
Yeah.
With the landlord and the tenant. And, a lot of people think when you're retained by a client it's one-sided, and we're coming in with all of our ammunition and
yeah, no, definitely not. I obviously am acting on the best interest of
course,
of my client, right? But at the same time, like there's no need for me to go in there and bully the tenant and be all harsh. We're not trying to do that. We're trying to settle an issue, right? We're not trying to fight, right? So and even when you go to a hearing, you're not there to fight, you're not there to argue, you're there to settle an issue with an adjudicator. They're just, in that case, the adjudicator is making the decision. Yeah.
That's a great answer. Thanks, Caleb.
Yeah, of course. I'm glad I was able to kind of touch on some of these issues. Yeah.
Yeah, that's good. Well, let's roll on to the next question there, Brian.
All right. So for the next question, my ex-tenant owes me $29,200 in rent arrears. I'm not sure what to do next or how much it's going to cost me.
So we actually have something really exciting today, right, Paul?
Yes, we do. Something really different. We have a third camera angle.
Yeah. We have another paralegal that is on the line with us. Someone very near and dear to us, right?
She's her name is Kaylee, and she's one of our licensed paralegals with Ontario Landlord Help Group. So she is on camera angle 3.
Okay, so once you get your order from the landlord and tenant board, typically what you do first is you transverse it. So what we would do is we would take your order and put it into and transverse into a small claims, so we get a number. This typically runs you about $45 to do. When you hand it over to us, we ask for about $1,000 retainer. That $1,000 retainer will get you about 4 hours worth of work. So that would include transversing, and then depending on the situation, it can go into a garnishment, it can go into a judgment debtor exam, it can go into a motion. It kind of depends on the situation, but whatever the situation may be, we know how to handle it.
Great,
Sorry for
perfect. That was a really great response there. So we're going to move on to the next question here. So I file a L1 application but submit the wrong copy of the N4 notice with missing details. My hearing is in March but can't do it over. I give the tenant the right copy of the forms.
Okay. So, believe it or not, this is not an uncommon issue.
We get it all the time.
Yeah. So sometimes what will happen is, you're filling out a notice, right? And you putting all your information, and you're like, oh, I made a mistake. So you do a new one, right? And that's the one you serve on the other party. But when you go to file your application, you're seeing 3 N4s in your documents, and this is the one. So you submit that one, and you make that mistake. The thing is with that is applications are amendable. So there's always an opportunity that you can re-upload the proper notice. The challenge with that is if the tenant, in that case, doesn't show up, an adjudicator more often than not, they will dismiss the application because they can't confirm which notice was actually served on the tenant without questioning the tenant, right? The tenant would have to provide, evidence that they didn't receive the proper notice or that they did receive it's impossible to find out without the tenant being there. Yeah. If the tenant does show up, the adjudicator may allow it, or if they're able to kind of, investigate to see what notice was actually served on the tenant. Because it's not so much about which one was submitted, but which one was served. So you're in a situation where it's at the discretion of an adjudicator, depending on the circumstances. Is the tenant there or not there?
Mm-hmm. Right. So, I mean, if we already have the L1, if we already have the hearing scheduled, I mean, we're kind of a game time decision on what the landlord would do at that moment. What would you suggest in that case?
You have 2 options. Your first option, so we're in December, right? And the hearing is in March, right? If you've waited, a year for it, you might want to just go to the hearing. Maybe the tenant shows up and you're able to, amend the application. So you upload the proper N4, right. You notify the LTB, and then you go to the hearing and you speak to the adjudicator. Maybe the tenant doesn't show up, but you don't have anything to lose, I guess, by just seeing maybe the tenant's there. And
so
it's not
an error on the form. It would be that you sent the wrong copy.
You sent the wrong copy, or didn't upload a copy at all, right? So these are things that happen, right? Either people make a mistake and they put the wrong document there, but it's amendable. Applications are amendable. It's just nothing's guaranteed. I always just like to let people know that things can happen, but nothing is guaranteed. You have to let an adjudicator use their decision-making power.
So I guess at this point it's December now. We have a hearing in March, let's just say.
Yeah.
Could they issue another N4, or that would be not advisable at that point?
I mean, you can serve another M4 and then refile and withdraw the current application, right? But the waiting time, you're resetting the clock essentially. Right. And so you might think, okay, if I'm resetting the clock, what is that going to do for my situation? A lot of times you're in rental arrears. Maybe that rental income is actually paying the mortgage on your home. So you have to kind of weigh your options. If you're in a situation where money, you definitely need to get that money, or you need to get the unit vacant because you have to have a paying tenant, maybe you just try it. Maybe you go to the hearing and see if the tenant's going to be there, and you speak to the adjudicator. And they give you an option at that time to withdraw your application if need be, right?
Right. So this is what I'm thinking on this, and let me know what your thoughts are. I mean, we don't know. We don't have really any other substance to this question.
Yeah.
But I guess they've already started this process. We have a hearing in March. Let's just assume that the tenant's not paying rent at all.
Yeah.
Okay. Let's just say the rent's $2,000 a month.
Yeah.
I mean, we have January, February, March. We have another 3 months. So we're looking at 6,000. And let's just say this process started in September. So, we have another 4 months or so. So they're almost like $10,000.
Yeah.
of rent owing.
Yeah.
So this landlord contacts us. I mean, I would want to kind of start a process of just communicating with the tenant. Maybe there's just a complete communication breakdown
Yeah.
with
Yeah.
the tenant and the landlord,
Yeah.
and they just can't see eye to eye anymore, and they can't even be in the same room.
Yeah.
You know?
So that's exactly, that kind of touches on what we were discussing before about negotiating,
Right.
right? It may just be an issue. It may be just a thing of having a conversation and seeing if there is some way to come to an agreement, right? Maybe it's a discussion of waiving rent arrears. Maybe it's a discussion of, the tenant saying, okay, can I do a payment plan or something like that, right? To start paying back the arrears. So I'll start paying rent with an additional, 200, 300 on top to start paying back the arrears.
Mm-hmm.
Maybe it's that kind of conversation. You don't know, but you're waiting for your hearing anyways.
Right.
And again, there's no loss in just mitigating some of your loss and just trying to have a conversation, because you may not know where that other party is, and maybe at first you tried talking to them and it didn't work out, and maybe their circumstances
Try
have
again,
changed.
because at some point,
Yeah,
they're going to be held responsible for that debt.
yeah,
you
yeah,
know? And I mean, if we can come in there and just have a conversation with the tenant, and keep it nice and easy, nice and calm. We want to talk to the tenants as if we're understanding them and hearing their story.
yeah,
And at that point, we want to hear why they're not paying the rent and what the reason is.
yeah, absolutely,
And be able to kind of decipher the next steps of that conversation.
exactly,
And that's all part of negotiating and what we do really well.
yeah,
So I think that's what I would want to do, take that approach and offer that tenant, like you mentioned, some type of plan.
yeah,
But then also talk to the landlord on a separate conversation and say, look, we have 3 months here
yeah,
that this tenant is not paying rent and probably has no intentions of paying any rent.
yeah,
There's $6,000 there.
yeah,
You're going to lose, guaranteed.
yeah,
Why can't we just offer the tenant $6,500
exactly,
to leave?
exactly,
And most times they probably will take that.
yeah,
And in that offer and in that deal, we're still not discussing what that tenant owes.
yeah.
So we're still going to chase them after the fact.
Yeah, I would. I wouldn't. I wouldn't. I wouldn't want to. Use a strategy that would be unfair, right? I mean, if you want to do that as yourself as an individual, right? My job is to still kind of maintain my ethics, right? So if a landlord wants to waive rental arrears or not waive rental arrears but pay, right, and say, look, you still owe me, but I'm going to pay you, it's up to maybe the tenant will decide that money that I'm receiving I'll use to pay towards my arrears, right? That's it's their choice, right?
Yeah.
Whatever the agreement is, though, between the landlord and tenant, right, to resolve it, that's the agreement. If the agreement is to waive the arrears, if there was, then that's what it is. If they didn't agree to waive the arrears, then
So I mean, and usually the landlord's going to know, whether the tenant has any means of paying this or if they can.
Yeah.
And they got to make a game time decision.
Yeah.
On, hey, what's gonna fit their wallet best.
Yeah. If it, in reality, you're not, that the tenant can't pay you back, maybe it's better for resolution, and if it's not going to hurt your pocket, right? You can stand to lose maybe $5,000 or $6,000. Maybe it's not going to hurt your pocket just to say, okay, go about your business.
They're going to lose it anyway.
Yeah, you're going to lose it, right? So, it's like you said, it's a game time decision where you have to look at what your situation is.
And realistically, if we get them out within, if we can push a deal where we can get them out in 30 days, 45 days, well, they can re-rent this in a reasonable amount of time, collect first and last month's rent, and be on the right page of moving forward.
Yeah, kind of covering those losses.
Yeah. That's a great question. I think we got into a lot of detail there.
Yeah, it's definitely a lot of nuance that we could explore.
Yeah, for sure. I did get a live question here. I don't know. What do you think? Do you want to talk about the live question?
Run it by me. What do we got?
Okay, let's. If you wanted, we were gonna bring it up. Cool. Well, let's do it. Let's see what that ends up with.
Okay, so for the live question that we had is well, there's two parts, I guess, or two questions. So we'll address both of them.
Sure.
What is the fastest way to remove a tenant who does not pay rent? And then the second half of that question will be, or another question, how does the bank deal with the property when there is a tenant who does not pay rent and landlord is not able to pay the mortgage?
Okay,
The
so
bank.
yeah,
The bank doesn't care.
I can't really
Yep.
speak to the bank,
Yeah.
right? That's a conversation that you'd have to have, with your advisor, your financial
Yeah.
advisor, right? But with the
Well,
question with
the
the
bank doesn't care. So I mean, the bank doesn't care.
yeah, I mean
You
whether
know.
there's a
Yeah.
tenant or not, you still have to pay the mortgage,
Yeah.
right?
And all the expenses.
Yeah.
Your insurance, taxes, and you know. But yeah, let's go to the first question there. The fastest way to remove a tenant who does not pay, just
Negotiate.
that's it. Just kind of what we just talked
Yeah.
about right now.
Negotiate.
Yeah.
If you have a tenant that's not paying, if you're asking me what the fastest way is in general,
Cash for keys.
is cash for keys
Yeah.
or rent waiver,
Yeah.
right? So you're gonna waive rental arrears, or you're gonna offer them. It's the same thing. It's cash for keys. So you give me the keys, I'll waive your rental arrears, or I'll pay you, right? If you're asking me what the fastest way is through an LTB process, there is no fastest way.
Mhm.
You have to follow. You have to follow the process: serving the notice, filing the application, and getting an order for an eviction from an adjudicator.
Yeah, we get it all the time actually. In we propose this every now and then. It all depends on the situation. But a lot of landlords say, I don't want to give them any money. They don't deserve a penny.
Yeah.
And I'm here for purpose, and I don't want to pay the tenant a penny.
Yeah.
And that's completely understandable.
Yeah. Yeah. There's a lot of emotions involved a lot
Yeah.
of times with these situations. But if you remove the emotion and you think, if you just calculate the numbers, right? You want your property back,
Yes,
right?
as quickly as possible.
As quickly as possible. So you have to look at what's most important. Is it more important just to, I don't want to pay the tenant to send because you're principled and that's, by all means that's what you want to do. Then that's what you want to do.
Yep.
But if the real goal is like, I just want to get my property back, I want my unit vacant, and that's what you're focused on, and that's genuinely what you want, then you may have to compromise somewhere, because without compromise, you're not going to get to an agreement.
Yeah, you couldn't have said it any better than that. And that's where we would have the conversation with the landlord and give them the advice that we see. And I'm a numbers guy.
Yeah.
And I base a lot of my business on numbers, but also on understanding people.
Yeah.
And there's different ways of understanding people in the way that they think, especially coming down to a tenant. So, to answer this question, I would say it depends on the landlord's specific circumstance. But if you know that you're going to be carrying a loss for some time,
Yeah.
then it's probably advisable to come up that calculate a number that makes sense, that you know where your losses are, and have a plan where we can go after the debt later on.
Yeah. Yeah.
That was a good live question. Thank you, landlord, for answering that. We're gonna jump back to our scheduled questions here. I see we have another live question, so maybe if we do have time after, we will get into that. Yeah, let's jump into the next question here.
Sure. So the next question that we have is, my ex-tenant owes me around $15,000 in rent arrears. He is self-employed. What are my options in recovering the debt?
So I think this is a question we can throw back to Kaylee, who's on standby there, and let's kind of hear what her thoughts are on that.
So you have a couple options. Just because they're self-employed doesn't mean that automatically means that they can't be garnished. But you have to find out where you can get that money from, because they pay themselves. So what we would do for you is we would set up a judgment debtor exam. So a judgment debtor exam is when you serve them with that they have to appear in court and they have to bring in all their financials, so their bank statements, their pay stubs, their notice of assessment, any T1s, T4s, any information that they have that shows that what income and what assets they may have. At that point, we hand it over to the judge. We ask them questions about where their bank, how much money is in their bank account. Do they own any cars? Do they own a house? Any assets they have. At that point, we can kind of go in the direction of how we are going to recover the debt. So whether that is garnishing their bank account, putting a writ on a car, putting a writ on a piece of machinery, a house, or sometimes they don't bring all the necessary documents that they need. So in that case, the judge will give them another chance and then order them to bring all the information that they do need for their next hearing. So like I said, so they would order them to bring banking information, uh, any assets they have, any T4s, T1s, notices of assessments, any information that could be helpful to recover the debt that they owe.
So we're just going to move on to the next question here for Paul and Caleb. So this one's a little bit longer. So um, it's from someone who visited us last week on the Paralegal Live.
Oh, very nice.
So
that's great to see.
last week, you answered my questions regarding rent raise and suggested to serve N4. I'm just not sure where the new amount will be on record. Do I need to provide him a new lease agreement, or adjust his current with the new rent amount, but nothing else adjusted in his contract? My tenant 1 year lease is expired and now he is on month to month. Already served him N2 from 90 days ago. Or N2 form 90 days ago. My unit was built after 2018 November. And obviously he didn't agree on the $100 raise, so I'm moving forward. Where do I adjust that in our records in order for me to serve him the N4 for missing payment on his next payment, where he is clearly not going to pay the new amount, and then the L1 in 14 days? Thank you.
Okay, there's a lot here.
Yeah, that was.
We almost have to break it all down.
Yeah, I was taking notes in my brain
Yeah.
as the question was coming in. I'll say this: it sounds like you'd benefit from actually talking with a licensed paralegal.
I think so.
Yeah,
It sounds pretty complicated.
it sounds like you're having.
hearing it.
Yeah.
Yeah.
I mean, I can say that. Probably similar to last week, and I hate to kind of give the same answer, but if you've served a notice of rent increase, right, and the new rent is coming due and it's not paid, then you would serve an N4 for that rental amount. The nuances of how you establish that rent, and in the event that you have to go to a hearing, so for an L1 application or something like that, that's a discussion I think is better had in private. And I can if it's with me or if it's with another licensee, they can sit down and explain to you kind of what evidence you're going to provide to show the new rent and things like that. But it's the same thing. If whatever the rent is that's owed or that you believe is owed, right, and you have evidence that that's the rent and they don't pay it, that amount that's not paid is your rental arrears, right? Mm-hmm. So the notice itself will be straightforward. Maybe how you handle your L1 application or your hearing, that might require some nuanced discussion on evidence or maybe arguments, right? But for the time being, if you have rental arrears, you're serving your N4 as no different than any other time.
Right. Yeah, he did ask here. Sorry, I'm not sure if it was a he or a she, but they did ask, do I provide him a new lease agreement.
So no,
no.
I mean the short answer is when you do a rent increase, you don't need a new lease, right?
Yeah.
If you sign a new lease with your tenant, whatever rent you put on the new lease is the rent, right?
But is that valid?
It would be valid if both parties are signing and starting a new lease, right? But it wouldn't have anything to do with the N4. You're essentially starting a new tenancy, right? In this regard, you don't need to start a new lease. You've served a notice of rent increase. That's what is establishing the new rent, not the lease, right? But landlords do have the option of signing new leases every year with their tenants if the tenant wants to, but there's nothing that forces a tenant to agree to signing a new lease. Yeah.
Okay, yeah, there's a lot there, so I think it's best to break it all down with a paralegal. Just exactly what Caleb said.
Yeah.
Because it's hard just to kind of have a paragraph of a question and to be able to answer it when there's just a lot of moving parts to it.
Yeah, yeah. There's some parts of that I'm not going to know, in a quick question, and even then, it's not advisable to discuss all the details of your case, just in an open forum, right? So, but I appreciate the question, and more than happy to spend 15 minutes in a consultation, and we could dig deeper into it, and maybe you can kind of put some things in your own words and get a better answer.
Yeah, great.
Yeah, for sure. And Sarah, if possible, would you be able to drop the link in the chat for the 15-minute free consultation? So definitely we'll be able to better serve you that way if it'll be a bit more personalized than rather the open form. So please do reach out to us. We'd be more than happy to help you out. And so for the next question, we have here actually a comment. So I'm just going to read it word for word here, and then we'll kind of decipher what it means.
Yeah.
So the question is, what the tax end of year if you don't get rent, you have lost income? So maybe something about like reporting on your taxes potentially. I'm not 100% sure, but if you guys want to take the floor with that.
Okay, I would just like to comment because we're getting a lot of questions, not just on this feed, but other emails. So this is why I'm reading the questions off on my phone. Just let me read that again so I can really understand that. Can you read that again, Brian?
Yeah. So off of the comment there. So what the tax end of year if you don't get rent? You have lost income.
I see. Okay. Yeah, this wouldn't be a question for us.
No. So this is not in the scope of what we do, and even like tax laws, what is not in the scope of paralegal.
No.
So I can't answer that question. I can't really speak to it. What I would say is maybe seek the advice of either like a financial advisor, or an accountant, or speak to a lawyer. There's a couple options out there to talk to somebody.
Yeah, we do apologize. That is a great question, but it just wouldn't be in our scope of
what we
answering
do here.
that with an exact, precise answer that you're looking for.
Yeah.
Yeah.
I hate to waive it, but like I can't speak to it.
Yeah, but thank you for asking the questions. We truly appreciate it. And, but if you have any LTB questions, we're here to answer those questions. So thank you.
Okay, so on to the next question here. I'd like information on the live event Paralegal Wednesdays schedule and link. Is there an archive? And then here's the paralegal question.
Yeah.
So I think actually I can answer the first one there.
Yeah.
So we do Paralegal Wednesdays. So we just started launching this live through the Facebook group, as you can see here. We do post the VOD, the video on our YouTube about a day or two later, depending on kind of timelines and deadlines for editing and what we got going on at the office here. So usually we try to get it up onto YouTube for the next few days. So if you miss the actual live on the page, which sometimes it actually posts on the actual official Facebook page. You can go to our YouTube channel. Make sure you hit subscribe because we are trying to get to 1,000 subscribers, so then we can also broadcast on YouTube as well. So we also have posted a link for you to submit your questions ahead of time, where we will moderate and look through those questions. And yeah, I think that's all of the questions that you had answered there. So now for the paralegal part. Can assigned parking be removed? A, when it's a part of the rental agreement. B, when it's in a separate agreement to the rental agreement. What amount of notice is required? What are valid reasons? And then there's a second part of the question, which I don't know if it's tied to the parking, but what abatement is required? The one I have that is in a separate agreement indicates the monthly fee. Thanks.
So we'll go in phases of the question, right? So we'll kind of break it down step by step. So can assigned parking be removed? A, when it's part of the rental agreement. So if in the rental agreement you are, offering, parking, one parking spot, maybe a storage unit or something like that. There's amenities that are added to the accommodation of the rental unit. Typically no. Whatever is on the agreement, yeah. And it's if it's on the lease, right, then the landlord's responsible to maintain those added amenities or accommodations, right? At times, there may be a reduction in service or a ceasing in service for a time, right? So let's say there's a pool that the tenant's supposed to have access to, and maybe maintenance is being done on the pool, so the tenant can't use it, right? So these things do come up. Complete removal of an amenity from a lease is not typically, possible, unless like it's a situation where like the landlord has no choice. For example, the entire driveway has to be removed for a period of 6 months or 7 months. For some reason.
The city might be doing some plumbing work or street work,
whatever, right? We can't say what it would be the cause, but for no fault of the landlord, they can't provide that. So that is something that could be done.
It just seems like in this case, it could be where, let's just say that the landlord lives in one of the units and the tenant lives in the other unit, and they are sharing a driveway, let's just say. And it was agreed upon, whether it's in a lease or, if the tenant has been doing it since, 2010, and there's no signed lease, it's month to month, it's still the same thing, right?
Yeah. Whatever is agreed, whatever is agreed to between the landlord and the tenant is a part of the agreement. So even if it was a separate agreement to the rental agreement,
right,
if it's an attached term, right, or even if it's an agreement made outside of the lease, once that agreement is made and it's being honored for a period of time, right, that is something that the landlord has agreed to, then they have to maintain it. If they have to, for some reason, remove access, there has to be a valid reason, right, other than I just want to remove it, right? And then, yes, there is an abatement. So the abatement could be anything from returning the fee, or not charging
if they're
the fee.
Charging a fee for the parking.
Yeah. And maybe
or if it's all built in.
Or if it's all built in, removing that portion from the rent. Or they may even have to pay for parking accommodations. Let's say if there's street parking and you have to have a street pass and now the tenant can't use the driveway, that landlord may have to pay for the tenant to park on the street, right? So, if there's no need to remove it, I wouldn't, right? But if you have to, there is a potential that it could cost you.
Mm-hmm. Yeah. So they said when it's a part of the rental agreement, you covered that. When it's in a separate agreement of the rental agreement, but then it would still be part of the agreement.
Yeah, if it's attached to the rental agreement, then it's still, as long as it doesn't violate any section of the RTA,
Right.
then it
So
can still be valid.
what if they signed a lease with the tenant last month, and then the landlord agreed the month after, just put it on a piece of paper saying, hey, I'm willing to, let you park for $50 a month.
Yeah.
And then the month after, the landlord says, you know what, I don't want this deal no more.
Yeah.
Would that be still part?
Yeah, it can still be considered, even if there was no piece of paper, it could still be considered, a part of the agreement. Actually, I had a situation where a landlord agreed to discount the rent, and on the lease, and then extended the discount, right? And they wanted to know if that extension was enforceable, right? And I said, yeah, because you've agreed to it, right? So it's now become an attached term to the lease, right? Both parties are agreeing to this new term, right? Contracts can be amended after signed, right? So you can sign a contract and you can amend it after signing it, right? As long as both parties are agreeing.
If they agree. So they can even settle on this and come up to some type of an agreement.
Exactly. They can change the nature of the agreement and say, okay, how about we're going to do this or whatever, right? So
and then get it on writing.
Yeah, you can.
Absolutely.
You can get it on writing and have it be a new attached term.
Yeah. Okay. Yeah. Those are some really great questions. Even Brian, your follow up there about the YouTube and the archiving, etc. That was an absolute great answer. But yeah, so check out YouTube, and these videos get posted there, and you'll see Paralegal live Wednesdays every single week.
Yeah.
So yeah, you'll be able to go back to last week's video. We have a lot of great information and some really, really great, unique questions in there as well.
Perfect. All right, so we're going to move on to the next question here. My tenant said she lost her job and cannot pay rent, but is willing to vacate. Aside from getting the N11 signed, should I also initiate the L3 with the LTB? Also, can I retain some of the deposit to cover for early termination of tenancy? Thanks.
Actually, this isn't really a judgment enforcement or enforcement request type question, but I think this would actually really this is something that I've discussed in detail a lot with Kaylee, and she has some good points on it. I'd like to get her to kind of respond to this question. In the interim, I'll say submitting the N11, good idea, right? Good idea. You can initiate that L3 process. Not a problem. You don't really have anything to lose other than just a filing fee, right? You never know. Just because the N11 is signed, maybe that other party turns around and says, you know what, never mind. I'm gonna hunker down, right? Yeah. You don't know what could happen, right? So it's always best to kind of look ahead and be prepared. But with regards to the deposit, do we have Kaylee there?
All right, Kaylee, I'm gonna just reread the question for you here. My tenant said she lost her job and cannot pay rent, but is willing to vacate. Aside from getting the N11 signed, should I also initiate the L3 with the LTB? Also, can I retain some of the deposit to cover for early termination of tenancy? Thanks. Caleb was just mentioning kind of your opinion because you guys have talked about it.
In the last week, I've actually filed quite a few L3s based off of N11. So it's kind of funny that this question came up right now. Yeah, so for sure, like Caleb was saying, always turn it into an L3, just for that protection that they will for sure be out by the termination date. And as for the second part of that question, the last month's rent can only be the deposit can only be used for last month's rent. In Ontario, that is like the law. It's not allowed to be used for anything else. So to answer your question, no, you cannot use it for anything else.
Perfect. Thank you, Kaylee. So do we have another question here? It doesn't look like we have any of our preloaded questions. If you guys want to talk a little bit about OLH kind of what's going on right now, give us a little bit of an update. That would be really great.
Sure, and then we'll just finish it right there. Unless we have any other live questions, I'm not sure. I do see one about the correct landlord can increase whatever they want if built after 2018.
Oh, we can
Even double, not rent controlled. But let's just, do you want to dive into that question?
I
or-
mean, yeah, we can touch on it. I'd like to give some insight if I can. So, rent increase. So this is a very controversial issue in Ontario right now. Non-rent restricted, homes, right? So can you just increase the rent to whatever you want? The short answer is, at least from what we're seeing, is yes. All right, as long as you're following the proper process. So typically, you're serving an N2, and you're putting the rental amount right. It's still the same as any other rent increase. You can't do 6 or 7 rent increases within a year, right? You can't just serve 15 rent increases if you want. But, just keep in mind, as you're increasing the rent, right, you can increase the rent as you like, but the tenant may not be willing to pay it, right? So you still want to be reasonable with your rent increases. If you, for example, have a tenant that's paying $2,500 a month, and you want to increase the rent to $10,000 a month, you're not gonna find anybody on this planet who's going to, I'll pay that, no problem,
exactly,
right?
yeah.
So, you're likely going to encounter someone who's going to say, I'm not paying the rent, or they'll just leave the unit, right? So try to be reasonable with your rent increases, but for the most part, yeah, you can go above the guideline rent increase without any issue. As what I've seen so far. It's still in dispute, even among other licensees. The conversation is, some are saying no, some are saying yes. From what I'm seeing, landlords are doing that, and they're using the N2 as the method to do so. So
Right.
we're still waiting to see what the final decision on that is.
Right. Okay. Well, thanks, Caleb. I think that's pretty much the conclusion here. Do we have anything else, Brian?
So in terms of we just want to thank all of the landlords who have joined the group and really come forward with their concerns, and being able to rely on us and the community that we've been able to build together. Really appreciative of that, and we look forward to continuing to serve landlords across the province, and to really make it a better landscape for all. It's been I joined this company around 4 months ago, and it's really been an honor to work day in and day out with the team here, and with you guys via social media and through our YouTube content and through our email newsletter as well too. So definitely, I want to thank everyone who has been involved, has been engaged. If you haven't been yourself, we do have a bi-weekly newsletter. We do have our final one for before we take our holiday break being released. So Sarah, if you're able to post a link, it would be really beneficial. We give updates about the different content that we release. We give updates about different news articles. We give updates from our trusted businesses, updates from Paul. So it really gives you kind of the inside scoop of what we're doing here at OLH and what is going on in
And
in
this
the
week we have
industry.
something very, very special that we're going to be introducing.
Yeah, for sure.
Should
So
I-
if you want to be the first to hear those announcements, definitely subscribe to our newsletters. Confirm opt-in. So once you hit subscribe, it's going to send you an extra email saying like, "Oh, are you sure that you want to subscribe to this?" Please hit that. That's very important to us. We want to make sure that we're sending emails to the right people who actually want our newsletter. And it's been an absolute pleasure these past 4 months to be able to work day in and day out, and we look forward to continuing to serve the OLH community from now and into the future.
Well, thanks, Brian. Those are some pretty kind words. I didn't write the script for you on this one, did I?
No, just right from the dome, right from the mind here.
No, that's great. Let me just add on to that really quickly, and then we're going to cut loose here. But this week's newsletter, we did something very special. We've been working really, really tirelessly on it. I mean, to a point of exhaustion.
Yeah.
We really have. And this week we're launching it, and we have a lot that is going to come. We put together a petition for landlords all across Ontario.
Yep.
And this is going to be launched in this newsletter, so very important to get into that newsletter. So that way you can see, especially the open letter that I have written for landlords all across Ontario. And it's not just landlords, it's tenants as well. We are creating a voice for all of the landlords all across Ontario. And we have some really, really great stuff that is about to come out that we're working on because we need to begin at least the process of finding a solution to change and to make renting better and to help landlords and to help tenants and to find a common ground between each other to be able to sit in the same room and find a solution so that way we don't have the problems that we're dealing with today.
Yeah.
We are seeing the brunt of the problems. We get calls every day from landlords, nonstop phone calls, emails, text messages,
live chats, comments.
Yeah.
Yeah.
And you can just see what's happening right now. And it has to change. We decided here at OLH Group that we are going to drive it.
Yeah.
And we're going to get behind that steering wheel, and we are creating a roadmap, and we are creating a voice, and we are finding a way, and we're going to spend a lot more exhausted hours on finding the solution. So
Absolutely.
landlords, it ultimately starts with you. We can only do what, the support that we have. If we don't have a following and we don't have support for this change and for this push and for this voice and for everything that we want to put together for landlords and tenants to change our system, we can't do it without you. Check out our website. You'll see right on our homepage a link there with more details on that.
Yep.
But you'll see in the newsletter more information is about to come. Check our YouTube. I believe my open letter that I wrote to all landlords across Ontario will be posted. I think it's going to be posted tomorrow.
Yeah.
Check that out. This is our last video before the holidays.
Yeah, I'm going to go spend some time with my wife and my family. What about you, Paul?
Well deserving, I'm going to do the same, and with my dog.
Yeah, yeah. I got two. You got yours, and I got my two.
Yeah, he deserves a lot of walks in the park. For how
yeah.
busy we've been.
Yeah, mine definitely have been complaining about being neglected, so I got to spend some time with them as well.
Yeah, absolutely. So happy holidays to everybody. We hope that everybody gets some time off and to be able to reflect, re-energize, and spend time with our loved ones, and remember why we're here. Remember why we're doing this today, and remember, that we are all landlords, and we have a common goal of, success and living happy, and hopefully one day all of us get a chance to live financially free, and that's our goal.
That is absolutely the goal. That's one of my goals, and we've had discussions, and we're still working on that. With me, but I'm glad to see that we're also able to kind of share that vision and kind of help landlords in their own pursuits.
Yeah. Well,
right?
even us, we are landlords too, and we talk every day about buying properties, investment properties.
Yeah.
And this is what we do.
Yeah.
So we're not just doing paralegal and helping landlords, and landlord coaching, and property management. We are real estate.
We're doing the work.
Yeah,
we're doing the same
we
work.
own properties. We have tenants. We have the blood in the game.
Yep.
We understand the issues, the problems. We get it. I mean, there's not too many, paralegal firms where the actual paralegals own rental properties.
Yeah. Yeah.
It's ask your paralegal if they have any rental properties.
Yeah.
I can't comment much more on that, but Same thing with realtors. When you're dealing with investment real estate, the realtor that you're working with who is finding you that rental property, do they own rental properties?
Mm-hmm.
Ask them that question, because
Yeah.
if they don't, well, would you really get the advice from,
Yeah.
your mortgage agent who has never dealt with mortgages before?
Yeah. No.
Probably not. But let's end it right there. 'Cause
Yeah.
we're gonna talk forever.
Yeah,
as you
yeah,
know.
we can go off on that all day, right? Yeah, absolutely. But great conversation for sure. And I think that next coming back a couple weeks from now when we do this again, hopefully we stimulated people enough that they want to get involved in the conversation. This is one way of doing it. Join us on the live, ask your questions, right?
Yep.
Talk to us, right? We're here. Book consultations. Like, you can have a consultation with me directly. It's not some robot somewhere. It's actually me. We're people in this office. But yeah, come and join us and get involved in the conversation, and check out the newsletter that's coming out. It's got some really great information in there, and I think it's going to really kick people in gear.
Yep. Let's do it.